Okay, let's talk about something that so many people go through: landlord-tenant disputes. You know, these disagreements are incredibly common, and let's just be real, they are super stressful. It doesn't matter if you're the landlord trying to get your property back or a tenant who's in a really tough spot, it can feel like you're lost. But what if you could walk into a lawyer's office already holding all the cards? Well, that's exactly what we're going to cover.
So, if you're watching this, chances are you're caught in the middle of a disagreement, right? Maybe it's about rent, or repairs, or you've just been served a notice that you don't understand. That anxiety you're feeling, it's completely normal, but it doesn't have to run the show. The next few minutes are all about giving you some clarity and, more importantly, putting you back in control.
And this right here, this is the main takeaway. If you remember just one thing, let it be this. Before you even pick up the phone to call a lawyer, the work you do right now to get your story and your documents in order is, without a doubt, the most powerful move you can make. This isn't just about being tidy, it's about building a rock-solid foundation for your case.
But why though? Why does this matter so much? Because being prepared completely changes the game. Seriously, it can shift the entire dynamic of the dispute and put you firmly in the driver's seat. Let's break down what that actually looks like.
Think about it this way. When you walk in organized, your lawyer doesn't have to spend hours, which you're paying for, just trying to figure out the basic story. That immediately saves you money. It also shows the other side that you are serious, which instantly boosts your bargaining power. It means your lawyer can get to work right away, which leads to the outcome we all want, resolving this thing faster and with a result that's in your favor.
All right, so where do you start? We're going to begin with the absolute bedrock of your case. These are the two non-negotiable things you need to do before anything else happens. First things first, go find that tenancy agreement. This document is your rulebook. Read it, and I mean really read it. What does it actually say about notice periods? Who's responsible for what repairs? Highlight every single part that's related to your problem. Second, you're going to create a simple timeline. This is the story of your case, told with dates. And look, this timeline doesn't need to be fancy. We're talking about a straightforward, chronological list of what happened and when. Tenancy started this day. I complained about the leak on this day. I got the notice on this day. A simple one-page document like this lets a lawyer understand the entire history of your case in literally minutes. That is an incredibly powerful head start.
So you've got your story straight. Now it's time to back it up with proof. We're moving on to building your toolkit. This is where you gather all the physical evidence you need to make your case undeniable.
Here is your essential checklist. Go through this list and find every single item. You need that agreement, of course, but you also need every rent receipt, bank transfer, any official notices, and this one is so important, all of your correspondence. And yes, that absolutely includes screenshots of WhatsApp chats. And don't forget dated photos or videos of the property. The goal here is to leave no stone unturned.
Now here's a pro tip that sounds small but is actually huge. It'll save you a surprising amount of money. As you're saving these files, name them clearly and consistently, just like the example you see here. A simple system like date_document_type_source means your lawyer isn't wasting billable hours just trying to figure out what they're looking at. This little habit pays off, trust me.
Okay, we've covered what you should do. Now, we need to talk about the don'ts. Avoiding these common mistakes is just as critical as all the prep work we just discussed. These are the traps that can seriously weaken your case, or even worse, put you on the wrong side of the law. Let's bust a huge myth right now. A lot of people believe you can call the police to evict a tenant or collect rent. The reality is, that's not their job. These issues are civil matters, meaning they're private disputes between individuals, not criminal offenses. Only the courts can order an eviction or enforce rent recovery. The police simply don't have that power. And here's another one. This is a biggie for landlords. The idea that you can kick a tenant out the day after they miss a rent payment, that's just not true. The law is very, very clear on this. You must follow a legal process. That means serving the proper legal notices and getting an official order from a court. Trying to do it yourself is illegal.
I cannot stress this enough. Do not take matters into your own hands. Changing the locks, moving a tenant's stuff out, no matter how frustrated you are, it's considered an unlawful eviction, and it can land you in a world of legal trouble.
Same thing goes for essential services. Cutting off the water or electricity to try and force a tenant to leave, that's another form of illegal pressure. It will absolutely not help your case and could actually lead to you having to pay damages to the tenant.
This should go without saying, but it's so important we have to say it. Never ever resort to threats, intimidation, or harassment. That can take what is a civil housing issue and escalate it into a criminal matter, which is a much more serious situation for everybody.
And finally, here's a golden rule for pretty much any dispute. Do not rely on verbal agreements. A promise someone made in a conversation is almost impossible to prove in court. If you agree to a payment plan, a repair schedule, a move-out date, get it in writing. Signed, written evidence is king.
So, after all this work, you've got your timeline, your documents are in order, you know what traps to avoid. You are now ready. This is the moment where you take all that preparation and use it to actually take control of the outcome when you finally meet your lawyer. This is what you walk in with, a nice, organized file. Inside, your one-page timeline, all your core documents sorted by date, and a simple, clear sentence stating what you want to achieve. Can you imagine the confidence you'll have? The impression you'll make? You're no longer just a client with a problem. You're a partner in finding the solution.
And because you're so prepared, you can have a totally different, much more strategic conversation with your lawyer. You get to ask the really important questions. What are my realistic options here? How much is this likely to cost? Could mediation be a better way to go? Asking these questions shows you're thinking ahead and helps you make smart decisions from day one.
And that brings us to this final thought. You've done the hard work, you've built your case, you know the pitfalls. You can finally stop focusing on the chaos and start focusing on the solution. With everything in order, you're not just reacting to problems anymore. You are now in a position to clearly define and go after the outcome you really want. The question is no longer, what do I do now, but what do I want to achieve?